The most common question I've received from my last video about leaving the UK is, how many days can I spend back in the UK once I've left without creating tax issues? So many people are considering moving abroad for capital gains tax planning purposes, and for the reasons I mentioned in that video, this will mean becoming a non-UK tax resident and remaining that way for at least 5 tax years. But understandably, people often want to go home to visit family and friends during that time. So this is a question that's important to consider when planning your tax residency. How many days can you actually get in the UK? So I mentioned in my reply to some comments that a good rule of thumb for most people is that if you spend less than 90 days in the UK, you'll usually be okay. But this is not universal. There is no one-size-fits-all approach because the UK residency rules are more complex than that. So this is just a quick video to illustrate how you work out the number of days you can spend in the UK whilst you're a non-tax resident without triggering UK tax residency. So if you're new here, I'm Andy. I've been an international tax advisor since 2014, chartered accountant since 2018, and on this channel I help you navigate the complex world of international tax. So in the UK, an individual's tax residency depends on the Statutory Residency Test, or the SRT. There are 3 sets of tests that must be considered and applied to an individual's circumstances to determine whether they are UK tax resident for a given tax year. These are the automatic non-residence tests, the automatic residence tests, and the sufficient ties tests. These tests must be done in that order. So if you meet the automatic non-resident test, you are a non-resident for UK tax purposes. No further tests are required. If you don't meet this, then you move on to the automatic residence test. Then, if you meet the automatic residence test, you are a UK tax resident and no further tests are required. But if you don't meet either of the automatic tests, then the sufficient ties test must be undertaken. And if you don't meet this test, then you're considered a non-resident for UK tax purposes. So let's get into what these tests actually involve. So first we've got the automatic non-residence tests. So there's 3 scenarios which could bring you into being non-resident automatically. So the first relates to time spent outside the UK if you were previously resident in the prior 3 years. So specifically, this rule says that if the person was a UK resident in 1 or more of the 3 prior tax years, and they spent less than 16 days in the UK in the year in question, then you'll automatically be a non-UK tax resident. So this will apply to a lot of people leaving the UK who've been living there for a while. So if you want to keep it simple, spend less than 16 days in the UK and no more questions are asked, you won't be a UK tax resident. The next one is time spent outside the UK when you were non-resident for the past 3 years. So specifically it says that if the individual was a non-UK tax resident in the 3 prior tax years and they spent less than 46 days in the UK in the year in question, then they'll automatically be a non-UK tax resident. So you can see that the rules are already slightly more favourable if you've been non-resident previously. So again, this keeps it simple and there's nothing else to be considered if you were previously non-resident for 3 tax years and you spend less than 46 days in the UK. Finally, we have the full-time work overseas test. So this says that if the individual works full-time overseas in the year in question, they also spend less than 31 days working in the UK, and they spend less than 91 days in the UK in total, then they'll automatically be a non-UK tax resident. A UK workday is defined as a day on which an individual works more than 3 hours in the UK. So if you're moving to a full-time job in another country, just ensure that you spend less than 91 days in the UK, and when you are in the UK, spend less than 31 days working there. So next we have the automatic UK residence tests. The first is very simple. An individual will be automatically a UK resident if they spent at least 183 days in the UK in a tax year. So if you spent 183 days or more, there's no more questions asked, you are a UK tax resident. So the next one's slightly less straightforward, and this is in relation to your home. So it says that you'll be a UK resident for the tax year if you have or have had a home in the UK for all or part of the year, and the following all apply. There is or was at least one period of 91 consecutive days when you had a home in the UK. At least 30 of these 91 days fall in the tax year when you had a home in the UK, and you've been present in that home for at least 30 days at any time during the year. Also, at that time you had no overseas home, or if you had an overseas home, you were present in it for fewer than 30 days in the tax year. So essentially, if you have an overseas home, you won't meet this test if you spend more than 30 days of the tax year in it. Now, some people worry that they don't have a home overseas because they don't own a property, but this isn't necessarily a concern. The concept of an overseas home for these purposes is quite broad, and it generally refers to a place where you live with a degree of permanence or continuity or expectation of continuity. It's theoretically possible for an overseas place to be an overseas home, even if you spend only 30 days there, provided there's some sort of continuity there. For example, if you always stay in the same accommodation whenever you visit Thailand, and you've stayed there a few times in the year, and those days all add up to more than 30 days over the tax year, then this could be considered your overseas home. So, a home could apply to a house, an apartment, or any dwelling that you regularly use as your residence, regardless of whether you own or rent it. This could even be a hotel if you live in it for a prolonged period and it serves as your primary living accommodation overseas. So you should keep records and evidence of living arrangements like rental agreements, Airbnb receipts, hotel receipts, utility bills, or any other documents that prove your residence and time spent there. Also, if you have more than one home in the UK, you should consider each of these homes separately to see if you meet the test. So you need to only meet this test in relation to one of your UK homes. So if you have 2 UK homes, but only spent 20 days in each, then you won't meet this test because you haven't reached the 30 days criteria in either one. So finally, we look at the work in the UK tie. And this says that you're automatically UK resident if you work full-time in the UK for any period of 365 days, and part of this period falls within the tax year in question. At least 75% of the days in the 365-day period must be days worked in the UK, and that's for more than 3 hours per day. So essentially, you have to have worked more than 274 days in the UK in any 365-day period, and some of those days must fall within the UK tax year. But many people don't fit either of the automatic tests, neither the automatic residence test or the automatic non-residence test. So that's why we have to move on to the sufficient ties test. So there's 5 ties to be considered, which are effectively connections with the UK. This is the family tie, accommodation tie, work tie, 90-day tie, and country tie. The more days you spend in the UK, the fewer UK ties are needed for you to pass the sufficient tie test and be considered a UK tax resident. So first we'll look at the family tie. So this says that an individual will have a family tie if any of the following people are UK resident in their own right. So this could be their husband, wife, or civil partner, unless they're separated. This could be their partner if they're living together as husband and wife or as civil partners, or their child if under 18 years old. So these are the only connections that can give you a family tie. Parents, siblings, cousins, or any other relatives in the UK cannot create a family tie. So next we've got the accommodation tie. This says that the individual will have an accommodation tie for the tax year if they have a place to live in the UK and it's available to them for a continuous period of 91 days or more during the tax year, and they spend 1 or more nights there during the tax year, or it's the home of a close relative and they spend 16 or more nights there during the year. For the purposes of the accommodation tie, a close relative is a parent or grandparent, brother or sister, or a child or grandchild aged 18 or over. A close relative can be a blood or half-blood relative or someone related through civil partnership or marriage. Adopted children are considered to be the individual's children for these purposes. Note, if you have accommodation but you rent it out, this won't be considered available to you for the time in which it's rented. So next we've got the work tie, and this is more straightforward. This says that an individual will have a work tie for the tax year if they do more than 3 hours of work a day in the UK for at least 40 days in that tax year. Another straightforward one is the 90-day tie. So this says that you'll have a 90-day tie for the tax year if you spent more than 90 days in the UK in either or both of the previous 2 tax years immediately before the year under consideration. And finally, we've got the country tie. So this says that the individual will have a country tie for the year if the UK is the country in which they were present for the greatest number of days in that tax year. So you'll need to count the days that you've spent in each country, and if you don't want to meet this tie, you'll need to ensure that the UK isn't the one in which you've spent more time than the others. So if you spend 50 days in the UK, you'll need to ensure there's at least one more country where you've spent at least 51 days. So the number of days that you can spend in the UK is determined by the number of ties you have and whether you're considered to be a leaver or an arriver. So if you were a UK resident in one or more of the 3 previous tax years before the one you're considering, you're a leaver. And if you were non-UK resident in the 3 tax years before the one you're considering, then you're an arriver. So this is the table for leavers, and basically this shows you how many days that you're entitled to depending on the number of ties you've got. So as we saw earlier, if you spend less than 16 days in the UK, you're always non-resident due to the automatic non-residence test. If you meet 4 ties, then you're tax resident by spending 16 days or more in the UK, so you'll need to spend 15 days or less. If you meet 3 ties, you're tax resident if you spend 46 days or more, meaning you essentially get up to 45 days in the UK. If you meet 2 ties, you're resident if you spend 91 days or more, so you get up to 90 days in the UK. And if you meet 1 tie, then you're resident if you spend 121 days or more, so you effectively get up to 120 days in the UK. And again, as we saw earlier, due to the automatic residency test, if you spend 183 days in the UK, you're always a UK tax resident. So as I mentioned at the start, 90 days can be a good rule of thumb, but it's not universal. It's useful because in most cases I see, people leaving the UK usually meet 2 ties, the most common ones being the 90-day tie and the accommodation tie. So in this case, with 2 ties, you can spend 90 days in the UK and not be a resident. But if you meet more ties, you'll need to scale down your days accordingly. So now we'll look at arrivers. As you can see in this table, it's slightly easier for arrivers to avoid UK tax residency. If you spend 45 days or less in the UK, then you're non-resident. If you meet 4 ties, then you're tax resident by spending 46 days or more in the UK, so you'll need to spend 45 days or less in the UK to avoid tax residency. If you meet 3 ties, you're tax resident if you spend 91 days or more, so you essentially get up to 90 days in the UK and so on. And as we saw earlier, if you spend 183 days or more in the UK, you're always a UK tax resident due to the automatic residence test. So ideally, you should review your situation proactively so that you can manage your UK days. You should look at the tax year ahead and anticipate your ties so that you know exactly how many days you're allowed to spend in the UK without triggering UK tax residency. Now finally, even if you do meet the SRT and therefore considered a UK tax resident, there is still some potential tax relief if you're leaving or coming back to the UK partway through a tax year. This is called split year treatment. There are certain qualifying conditions, but if you do qualify, the tax year can be split into 2 parts, a UK part and an overseas part, meaning you only have to pay UK tax on the UK part of the year. This can be a huge benefit because normally UK tax residents are taxed on their income for the entire tax year. So the ability to split the year and only get taxed on the UK portion of the year can significantly reduce your tax liability. So here's how it generally works. If you're arriving in the UK and you come to the UK partway through the tax year, the split year treatment might apply to you. This means you could be treated as a non-resident from the start of the tax year until you arrive in the UK. As a result, you would only pay UK tax on income or gains made during the part of the year when you're considered a UK resident. On the flip side, if you leave the UK to live abroad partway through the tax year, the split year treatment could also apply, meaning you're treated as a non-resident from the date you leave the UK. You would only be liable for UK tax on your income and gains for the part of the year before you left. The split year treatment applies only if you meet specific conditions detailed in the SRT. These conditions involve factors like your work situation, where your home is, and whether your family is with you. The rules are detailed and can be complex, encompassing several scenarios or cases under which the split year treatment might apply. Each case has its own set of criteria that must be met. So the split year treatment itself is multifaceted and probably needs a video all of its own, but for now it's important to know that it's something that can be really helpful for your overall UK tax situation if you're either leaving the UK or returning. To conclude, to check whether you're a tax resident under the SRT, you need to check the following in order. First, the automatic non-residence test, and if you don't meet that, the automatic residence test, and if you don't meet that, the sufficient ties test. Ideally, you do this proactively, looking at the tax year ahead, so you know exactly how many days you'll be allowed to spend in the UK without triggering UK tax residency. Finally, even if you do trigger UK tax residency, consider whether you may qualify for split year treatment, which may apply in a year in which you're either leaving or arriving into the UK. So hopefully this has provided a bit more clarity over what you need to consider if you're going to be a UK non-tax resident and how many days you might be able to get back in the UK. If you've got any comments or further questions, just give me a shout in the comment section below. Cheers.